we'll start up again.
Okay.
And, okay. So go back and tell me about the students actually being able to represent the clients.
Right. So at about the same time I was hired, the law school decided to incorporate a more student-focused center in all of the clinics. And at the time, that wasn't the way the clinic here worked. And in fact, most environmental clinics around the country, there's about 30 of them, work more staff-centered, where the students provide assistance to staff attorneys who run the clinic. And when we decided to change that focus, it sort of stirred up our client base a little bit, who were not used to having the student take the lead role. And they do take the lead role on everything. I mean, I am often not even in the room when they're on a call with opposing counsel or with their clients. In fact, I try not to be, so I'm not the center of that conversation. Now, in court, of course, I have to be there, but I take my hands and I place them under my seat so I don't jump up and, start causing a ruckus. But the students really need to learn to control that themselves.
And you find the students respond well to that?
It was not easy. My first 2 years, like I said, I had to physically put my hands under me to prevent myself from jumping up. But I've learned to trust them and also trust my ability to teach them. And they've excelled. I mean, I've had 2 students in the last 12 months argue before the 10th Circuit Court of Appeals. And I can't say I would have done, a better job. I mean, they're so dedicated to it. And they were so willing to spend hour after hour after hour preparation time that, it works out great.
Excellent. So when did Friends of Animals file its original petition? And kind of give me a little background, and then we're going to go through tell me what the case is about. Go through the case history a little bit, because it's been going on for a few years.
Sure. It's been going on for more than a few years, almost 15 years. It started before I arrived. It started in the late 1990s, so 1998, 1999, Friends of Animals began to work on a petition to list, at the time, 13 species of wild birds that are available in the United States for pets in the pet industry, to list them under the Endangered Species Act. The petition was completed and filed in 2000, and so close to 13 years ago now was when the first request to the United States Fish and Wildlife Service, which is an agency of the federal government and the Department of Interior, received the petition to list these species. The Fish and Wildlife Service, and again this is still before my time, did not initially act on that petition, that is, respond to it one way or the other. Under the Endangered Species Act, they had technically 90 days to provide an initial preliminary decision on whether the petition warranted further review. I think Friends of Animals waited well beyond 90 days, more like almost 2 years, before the clinic decided that took on their representation and filed the first lawsuit against Fish and Wildlife Service for their failure to even respond. That was resolved in 2003, and the Fish and Wildlife Service committed to respond to the petition. They still took nearly 2 years after that, and finally issued their decisions in 2005.
And what were their decisions?
Well, initially their decision was that the petition did not warrant any further consideration. And so that led to a second lawsuit by the clinic in 2008, challenging their decision not to move forward on the bird petition.
And so then they decided it was warranted?
Yes, that is right. They agreed to go back and take a second look at it, and we established a time frame for them to do so. By now it was down to 12 species, a 13th had been resolved. And they agreed to do 4, I believe, every 4 months, wrapping up basically throughout 2009 and into 2010. And so they followed that schedule, and every 4 months we would get an email that they were going to release the findings on another 4 of the species. And it's been completed, although there's still one bird that is being reconsidered right now.
Which bird is that?
That I don't, believe it or not, I'm not quite sure. I literally just got this email within the last week, and we haven't looked at it in thoroughness at all. So
what were the results of which birds have been listed? Because I'm not sure if that's...
Well, so far we've been batting 75%. So of the 12, 8 have been listed as either endangered or threatened. And the two that are most significant are the Scarlet Macaw and the African gray. So the other 3 that so far were not listed, I could get you that information, but you know, they were, we knew they were probably the ones that were less likely to get.
So the Scarlet Macaw has been listed as endangered, and the African gray also?
That is right.
Okay, so
and also the military macaw.
And the military macaw?
Yes.
Okay, what about the Hyacinth Macaw?
It was listed as threatened, which is a lower status.
Okay.
But yes, it was listed.
And speaking of that, can you explain the difference under the Endangered Species Act and kind of go into the act itself, explain what the difference is between threatened and endangered in the context of the act? And then I believe this was a citizen petition, was it not?
That's correct.
And if you could tell me the difference between a citizen petition and a government petition. Jay tried to go down that road. Unfortunately, I ran into him on my memory card, so I figured you would get that.
Sure, right. Well, so the Endangered Species Act has 2 processes for listing species. One is the citizen process. The other can be initiated by the Secretary of Interior. In reality, probably a good place to start is to know that since the act was, the Endangered Species Act was adopted by Congress in 1973, after a very initial flurry of government-led protection of species, listings of species, almost all species since then have gone through the citizen process. And the citizen process is open to anyone to provide information to the United States Fish and Wildlife Service on why a species warrants protection under the Act. And like I said, I mean, a vast majority, probably upwards of 90–95% of all species listed in the last 20 years have been citizen initiated. Now, you mentioned the difference between endangered and threatened. Well, I think that's in the eye of the beholder. It's probably more of a legal term than it is anything that the conservation community might accept as real. Obviously, endangered means that it is on the verge of extinction in the eyes of the Endangered Species Act and how the Fish and Wildlife Service applies it, while threatened status means that it is threatened to go onto the verge of extinction. And so that's to put it in rather simple, plain language. The Act really just talks about the level of threats to the species.
Now, what are the ramifications of that for the companion bird owner, the breeder, the retailer, the industry itself? Because it really is quite a large industry.
Right. Well, the ramifications, not just for the industry, but for,
and for agriculture itself.
Right. For anyone interested in the status of an animal underneath the Endangered Species Act, it is a significant difference. An endangered species, the prohibitions against take, which includes not only killing the animal or capturing the animal, but even harassing the animal. And obviously keeping an endangered wild animal in captivity is by itself defined as harassment. And so if a species is listed as endangered, the prohibition is absolute, and the only possible way for someone to get permission to take a species, even keep a species, is through an individual permitting process, which is intended to be a burden in order to make sure that species that are listed as endangered are given the highest protection, and that individual requests to take them are given serious consideration by the agency, Fish and Wildlife Service. A threatened species, on the other hand, the big difference, it's still subject to the take requirements, but Fish and Wildlife Service could promulgate a blanket rule that covers certain takes of the species. And so that if someone fits in that rule, that blanket rule, they don't have to apply for an individual permit. They just need to assure that what they're doing is within that. So we call that a Section 4 rule, which says, hey, look, at the species is threatened. We want to make sure that it's not taken, but there are certain things that we will allow that would not be allowed if the species was endangered.
Okay, and so what if a person, say, has a Scarlet Macaw as a pet? Is there a grandfathering clause? Because you really, is it realistic to seize someone's pet or to try and free it? Because birds that are raised domestically probably wouldn't do so well in the wild. I'm just curious how that works.
Right. Well, it's a very interesting question, and one that I think Fish and Wildlife Service still needs to figure out. If the species, like the Scarlet Macaw, is listed as endangered, then technically the owner would need to go and apply for a permit. Fish and Wildlife Service has indicated that when it comes to existing captive stock, that they're very willing to issue these permits. But it doesn't deprive, the person isn't allowed not to pursue that permit. Now, whether there would be an enforcement is another issue altogether.
Right, right.
So through the threatened provision, though, Fish and Wildlife Service has tried to, through these Section 4 rules, provide blanket allowances for birds currently being held as pets.
Sure. So
the distinction is real, and I think Fish and Wildlife Service is still trying to figure out how to handle the individual pet owners, the zoos, the conservation organizations. That's different. Those folks are expected to get the Section 10 permits. I mean, they do for most of their animals anyway that are, that are threatened and endangered. But the pet owners it's still not clear what the government's going to require of them.
what is a Section 10 permit?
So Section 10 is the permitting process that I sort of alluded to earlier, that if you still want to keep a captive endangered animal, you need to get that individual permit under Section 10.
And that would apply across the board to rescues and to everything, right?
Well, anyone, of course, could apply for it. Whether they can meet the requirements for it is another thing. And this is where the question lies on whether or not an individual pet owner would even qualify. The permits are intended to assure that the captive breeding's primary purpose, or keeping an animal in captivity's primary purpose, is to ensure survival and propagation of the species. It's not just intended for someone to say, I'm interested in keeping an animal. Mm-hmm. And so, yeah, Fish and Wildlife Service is still trying to figure out whether the individual pet owners would fall under that exemption, which is one of the reasons why they're preferring to list them as threatened as opposed to endangered, because that way they could go through Section 4, which they have much more room.
Much more latitude.
That's right.
There. So, let's see. What criteria do they use to determine if a species is endangered? And kind of discuss the foreign species provision in the Endangered Species Act, because that's a kind of a curious thing. A lot of people have asked me, well, why are we protecting foreign species?
Let me start with that question. Because actually I was in Cameroon, Africa, in December, giving a presentation on protecting African antelope in the United States. And of course, everyone in Cameroon was, why is this provision? Why are you protecting African antelope through the United States Endangered Species Act? They're more used to talking about international provisions like the International Convention on Trade of Endangered Species, the CITES provision, or some other types of regional international treaties that protect species in Africa. And I think it's really important that the history of the Endangered Species Act is one in which Congress, when they first looked at protecting species and ecosystems in 1968, really said two things. One, this isn't a U.S. phenomenon, right? Mm-hmm. This is actually something that we should be worried about worldwide. One, because species, the ecosystem's interconnected, and we could see major changes in the world if we don't have protections that are global. And two, of course, that they did care about the trade imbalance. I mean, if we were the only ones protecting species and other countries were not, that could give an unfair advantage to U.S. competitors. And so in 1968, when Congress first adopted the preliminary Endangered Species Act framework, not the one we have now, that was in 1973, they did so directing the U.S. State Department to make sure that we had a global treaty intact first. And that's actually what led to CITES. Mm-hmm. So by the time CITES was adopted in 1972 and Congress came back to adopt the Endangered Species Act in its current form, it had basically said, yeah, now this is important, we do it as well. And the reason it's important for us to do it as well is, one, to live to our commitments that we made in CITES, but also because we want to make sure that we're not a safe harbor